Before we begin, we'd like to acknowledge the traditional owners of the lands from which we're broadcasting today. I'm broadcasting from the lands of the Widjabul-Waiable people of the Bundjalung Nation. We pay our respects to the elders of the land, both past, present and emerging, and extend that respect to any Aboriginal and Torres Strait Islander people joining us today or watching the recording of this webinar. Welcome to this Youth Week webinar, part of our Law for Community Workers series, Problem Spotting for Young People. My name is Bridget Barker and I work in the Community Legal Education branch at Legal Aid New South Wales. And I'm joined today by your presenters, Jane Sanders from Shopfront Youth Legal Centre. Morning, Jane. And also by Lorissa Day from the Children's Civil Law Service at Legal Aid New South Wales. Our webinar today goes for an hour. After the webinar, you will receive an evaluation survey, and we do really appreciate any feedback you provide, and we take it on board. You'll also receive an email with resources that we talk about today in the webinar. Today, we're focusing on the law in New South Wales and services available in New South Wales. If you're joining from another state, those services may differ. So thank you for joining us, and I'll hand over to Lorissa now.
Thanks, Bridget. Hi, everyone. As Bridget said, my name's Lorissa. I'm a lawyer with the Children's Civil Law Service at Legal Aid. I'm joining you all today from unceded Gadigal land of the Eora Nation. And I'd also like to pay my respects to elders past, present and emerging, and also to anyone on the webinar today who is an Aboriginal or Torres Strait Islander persons. Welcome. So some of the topics that we'll cover today, we have a range of topics. The way that we're going to do that is that Jane and I are each going to present a scenario. It will be a fairly dense scenario, but it will cover a wide range of legal issues that we'll go through, identify, and then give you a little bit of information on. So some of those things are the differences between criminal law and civil law. I'm going to start with that in a moment. Then Jane's going to launch into a scenario which will cover fines and debts, motor vehicle accidents, traffic offences, police powers, and then it'll be over to me, and I will be doing a scenario that will focus on some out-of-home care issues like leaving care plans, access to care records, legal file audits, and property recovery and some family law issues as well. Thanks, Bridget. Great, so just to start with, we thought we would do a slide on the differences between crime law and civil law. This is just a very general overview, but will help you throughout the presentation. As Jane and I are speaking, hopefully some flags are going off. Oh, maybe that's a crime law issue, maybe that's a civil law issue. And it can also equip you when you're speaking with young people and they have a particular issue, you might know which kind of service they're going to need, whether you need to engage a criminal lawyer or a civil lawyer. So a criminal law matter is any matter where a person has been charged with a crime or an offence. I mean, they're usually the same thing, but it's where the police have laid charges against someone. These are almost exclusively laid by police. Now, the reason I've said almost exclusively is because technically any person can bring charges. I can bring charges against Jane, she can bring them against me. It just doesn't usually happen. And the police actually have the power to come in and take over those charges that we've laid anyway. So it doesn't usually happen. And generally when we're thinking about crime law, we're thinking about the police prosecuting someone for an offence. Some examples of that are criminal charges and also fines.
Can I just chip in? Other government agencies also could prosecute people, like work cover, for example, council rangers or whatever, Transport for New South Wales, when they're sending you out a penalty notice for a camera detected traffic offence. But yeah, the key is that you are being accused of some kind of offence or crime, and either you're required to go to court or possibly to pay a fine instead of having to go to court.
Yeah, that's exactly right. Thanks, Jane. Civil law is everything else. So that includes, we have some examples, claims, so such as personal injury, like motor vehicle accident claims, workers' compensation, claims against the state if you were suing the police or suing DCJ, something like that. That's a civil matter. Interestingly, AVOs on their own are a civil matter. Usually they're connected, not always, but it's very common that they're connected with some kind of a charge, like a common assault, and then the police will take out an AVO to protect somebody. But on their own, an AVO is a civil matter, and it's not a criminal matter until there's a charge associated, or if there's a breach of an AVO, that's then a charge, that becomes a criminal matter. But on their own, it's a civil law issue. Contract disputes, civil law issue. Care and protection, so anything involving DCJ, the out-of-home care system, that's going to be civil. Family law is civil. Employment, everything else is civil. So hopefully that provides you with some context. And I'll now pass over to Jane, who will take us through our first scenario. Thanks, Jane.
All right. Hi, everyone. Like Lorissa, I'm also coming to you from unceded Gadigal land today. I pay my respects to their elders, past and present, extend that respect to any Aboriginal Torres Strait Islander people who may be joining us today. I'm from the Shopfront Youth Legal Centre. We'll talk a bit more at the end, perhaps, about what our centre does, how we fit in with Legal Aid and other community legal centres. But I'm going to take you through a scenario first. You've already had a bit of a spoiler alert from Lorissa, who's suggested some of the legal issues that we might be covering. But I would like you to, when I go through this scenario, please just think about, can you spot some legal problems here? And I'm going to ask you to post in the Q&A. You can post anytime when I'm going through the scenario or at the end, what legal problems can you spot? Because we want to have a bit of a discussion about that. So I'll just read it out for you. You've probably been able to read it now, but Ash is 17. She's got her Ps, which is a really good start. And she's bought a car, great. But she hasn't transferred the rego into her own name yet because she's got a bunch of train fines and she can't actually transfer the rego into her name until she sorts those out. And also she hasn't got insurance because, well, who can afford that? And anyway, the rego's not in her name anyway, so how can she take out an insurance policy? She really, really needs to drive for work, but when she's earned a few bucks, she'll pay off her fine, she'll sort out the rego, and maybe she can even afford some insurance. Recently, though, Ash has received a few more fines. They've come in the mail. This time they're speeding and parking fines relating to her car, but they're not hers because they were incurred before she even bought the car. So she thinks that the previous owner has falsely nominated her as being responsible for those fines. And she's really worried about her licence being suspended because some of those fines carry demerit points. So she needs to do something about those. She's not really sure what. Next slide. Also, since she's started driving this new car, she's been pulled over by the police a few times. They keep saying they're stopping her for a random breath test, but she thinks, no way, there's nothing random about it. She really believes they're targeting her. A few times also the police have searched her car because they believe they're carrying drugs. She's never been busted with drugs before, so she doesn't think they've got any reason for this sort of suspicion. One of the officers told her, oh, it's because there's intel on the car. Next bit, once they even strip searched Ash on the side of the road. When she complained, they said, well, if she wanted privacy, they'd put her in the caged truck. One day, Ash is driving to work. She's in a bit of a hurry and she accidentally sideswipes another car. She thinks she might have left a bit of a scratch, but she can't be late for work, so she keeps driving. A few days later, she gets a call from her local police station saying there's a witness who's seen her crashing into another car and driving off. She knows the police hate her. So what's she going to do? Okay. Legal problem spotting. What legal issues can you identify? Or doesn't Ash have only a couple of weeks to transfer the registration? I think you are supposed to transfer the rego as soon as you buy the car. That's correct. I think also the previous owner has to send in a notice of disposal. And if they haven't done that, then that's something they can potentially get into trouble for as well. Do I have some answers here? So the chat's disabled, so you need to post it in the Q&A. Okay. Do we have any other legal issues? You don't have to tell us the answers. Just what are some of the legal issues you can identify? Come on, people. Unlawful strip search, thank you. Any others? Police unfair targeting, potential unlawful search of vehicle, yes. Fines, yes. Crash and not stop, yes. Possible fine for not stopping after the car hit, yes. Leaving the scene of the accident, yeah. So a few of you have suggested the same sort of thing. Yeah, that's definitely a legal issue. Driving unregistered, that's a point. The car might still have rego, but we don't know. Maybe the rego's expired as well. We know that it's not in her name. Okay, great. That's a really good start. That's certainly identified quite a few of the relevant legal issues. What we might do now is go through the scenario again, just with some of the issues highlighted. We don't have all day, we've only got an hour, and we've got another scenario to get through. So we're not going to be able to tell you all the legal answers to these problems, but just get you thinking about how to spot problems, which obviously some of you are already good at, and where you might be able, how to think about a legal problem and where you might be able to go for help. So first thing is fines. So I think most of you who work with young people would know that if you've got unpaid fines and you don't do anything about them for a while, it can affect your driver's license if you've got one, or your ability to get a license, book a test, register a car, and things like that. Now, there are special rules for under 18s. So if you're under 18 and you and your only outstanding fines are non-traffic fines, which are train fines, if your fines were non-traffic fines and they were incurred, I think, while you're under 18, then they cannot suspend or cancel your license. So if you've already got a license, your unpaid train fines can't affect your actual license, but they still can lead to a customer business restriction, which is Revenue New South Wales, the body which deals with fines, telling Transport for New South Wales, we've got she's got unpaid fines here, so you can suspend your dealings with Ash. So she can keep her license, but other business with Transport, she may find it difficult to do, so she can't transfer the rego into her own name. Now, if she doesn't transfer the rego into her name, we have plenty of clients who don't do that, and they don't necessarily get into trouble for not transferring the rego into their name, but they certainly often land up in trouble for other things because they crash the car, they're not insured. So it's just a really bad idea. Also, of course, it's a bad idea if you sell a car to someone, if you don't make sure that the rego is, that you send in the notice of disposal and the rego is transferred into somebody else's name, you can end up being liable for fines that are being incurred by the new owner. So yeah, her unpaid fines, her train fines need to be sorted out before she can get her car registered or get the rego transferred. I think most of you know about work and development orders, and I'm not going to go into detail about that, but that would obviously be a really good idea for Ash if she's eligible for a WDO and can find a sponsor to get her fine sorted out that way. Otherwise, she may just need to go on a payment plan. Now, she's got some speeding and parking fines which are not hers. So what does she do about those? Definitely not just put them on a WDO and pay them, because that might mean she doesn't have to sort of cough up with the money, but it means the fines will still be in her name. They will go on her traffic record, which might have implications later on, and she will incur the demerit points, which if she's on her Ps, if you're on your P1s, which she would be at 17, 4 demerit points means a 3-month licence suspension. If you're on your P2s, 7 demerit points it takes to get suspended. So she really needs to sort out those fines, and the answer is not to ignore them. If she was not the driver of the car, so with camera-detected fines for speeding, parking, driver use mobile phone, offences like that, if you are being sent one of those fines and you were not driving, the procedure is you need to actually nominate the driver to the best of your ability. If you know who was driving the car or responsible for the car at the time, or you think you know, you need to fill in the submit the form to actually nominate that driver. Or if you genuinely don't know, you have to contact Revenue New South Wales, seek a review of the fine, give them as much information as you can. Don't just court elect. So if you receive a fine, you can elect to go to court, which means saying, I'm not guilty, you prove it in court. But if it's a situation where you're saying, I'm not the driver, it's not just as simple as court electing. There is a procedure you need to follow, and that is by nominating who you think the actual driver was, or just telling them as much information as you do know. So definitely she needs to sort these out soon. I think it's much more important for her to sort these out than her train fines, because these fines left unattended will cause major trouble. Okay, next one. Okay, so we've got a whole lot of stuff here about police powers, possible harassment, possible targeting. Again, we haven't got all day. Once I start talking about police powers, I can't stop, so I'll really, really try. Clearly, yeah, there are a lot of potential issues in here. Fortunately, the police haven't found anything on her or in her car. Ash is someone who's never been busted with drugs before. She doesn't use or carry illegal drugs. She isn't carrying any knives, which is great. But of course, if police did find something, then Ash might end up with criminal charges. It could be something really, really innocent. She might have a knife in her glove box because, oh, it's just a pocket knife and it's handy. But it's not a lawful excuse to carry a knife around, usually just because it might be useful one day. We don't know where she works. I mean, she might be working a trade of some sort and have to carry around tools or whatever. So police might find tools. They might try to charge her with possessing implements or whatever. She's probably got a lawful excuse to possess those. Of course, if she objects to this, she complains, she might struggle against being strip searched, tell them to fuck off or whatever. She might end up being charged with offences like the trifecta: offensive language, resist police, assault police. So of course there are risks of, whenever the police are involved, there are risks of you being charged with a criminal offence, even if you are innocent, or at least if the thing starts off very innocently. Here, fortunately, Ash is not being charged with any criminal offences because she's able to keep her cool. Police powers to stop and search. Police generally can stop and search a person or a vehicle if they suspect on reasonable grounds that you're carrying things like illegal drugs, weapons, stolen goods or whatever. That suspicion's got to be based on reasonable grounds. Intel on the car probably doesn't cut it. Not on its own. Intel or intelligence is just information that is on the police computer system. It can be really good quality or reliable. It can be really poor quality, very, very unreliable. You know, the source is not even known. Intelligence on the police system is supposedly ranked in terms of how reliable it is. But often you have coppers just out on the beat, out on the street, they don't really inquire very much into that. Something comes up on their Mobi poll or over police radio, oh yeah, there's intel on that car. Often they just jump to conclusions and say, right, that's enough for us to search. So, yeah, intel on the car alone would not be enough for a search. It is true that police, of course, can stop a vehicle for a random breath test or a random drug test. They can do that without any reasonable suspicion, but there are a lot of cases where there's really nothing random about it, and clearly they are using random breath testing as a pretext for something else. They're actually not interested in RBT at all. They're just pretending that's what they're doing in order to actually stop someone, have a chat, and search them. Strip searching has special rules. They can only strip search if they believe, I might have the wording wrong, but the seriousness and urgency of the circumstances require it. And they have to give you reasonable privacy. And there's other rules for strip searches as well, particularly if you're under 18. So all of these things could be the subject of a complaint by Ash. She could ask somebody to help her make a complaint against the police. She could make that complaint to her local police or to the LEC, which is the Law Enforcement Conduct Commission. She could also potentially get some advice about a civil action against the police, and that is suing the police for compensation, particularly for the strip search. That could be an assault. It could be a false imprisonment because they've detained her for the purpose of the strip search. It could be an assault if they're touching her, and assault and battery. So potentially that could involve her taking an action against the state of New South Wales, seeking compensation for the harm police have caused to her. Next one, and I will finish this soon because we've got quite a lot. Okay, so she's crashed into another car. Fortunately, well, we'll just assume here nobody's been injured. If you leave the scene of an accident where someone's injured, then the potential offence you're committing is very serious and the penalties can be very serious. If you leave the scene where there's been some damage, that is an offence, but usually it's something which carries a fine rather than potential imprisonment, whatever. She's accidentally sideswiping another car, so she may well be guilty of an offence like negligent driving as well. So there are potential criminal consequences for perhaps negligent driving and also failing to stop and exchange particulars. So she might be given some penalty notices, meaning on-the-spot fines for those when the police catch up with her, or potentially she could be given a court attendance notice and have to go to court. Now, she's under 18. Some offences when she's under 18 could potentially be dealt with under the Young Offenders Act, meaning she could maybe get a caution or go to a youth justice conference instead of having to go to court. But because they're traffic offences and she's old enough to have a licence, they don't come within the Young Offenders Act. So it will be a fine or court proceedings. There could potentially, so a car crash is a really simple and common example of something where there can be civil and criminal consequences as well. Often if you run into somebody else's car, there may be offences you've committed, as I've said, and the police could be involved. So criminal consequences, you may have to pay a penalty of some sort. There could also be civil consequences as well, because the owner of that car is going to want to come after you to repay the cost of the damage. And so that is civil. That is a private claim, a private dispute between you and the owner of the other car that you've damaged, or maybe their insurer. Now, just finally, police are wanting to talk to her about this. Does she have to talk to them? General rule is you don't have to talk to the police if you're a suspect, but there are exceptions to that rule. And one of those main exceptions is traffic. So that if there has been a crash, you do have to give police certain information. If you were, police suspect that you were the driver of a car when there's been an accident or an offence committed or whatever, you do actually need to give them certain information. So this is something she can't ignore. If the police were wanting to talk to her about shoplifting or an assault or whatever, she's entitled to ignore them. Whether that's a good idea or not, well, she should speak to a lawyer about that. But a situation where police want to talk to her about traffic offences or accidents, she really does need to speak to them. Okay. So I think we can go just skip over those next slides because we've really covered most of these issues. And I will hand over to Lorissa.
Thank you, Jane. All right, problem scenario 2, we've got Grace. So same as Jane, I'm just going to read through the scenario, then I'll throw it over to you guys, see if anyone can identify any particular legal issues, and then I'll break it down and talk through some of the legal issues that can be identified. So Grace is a 17-year-old female who is under the care of the minister. She currently lives in a residential care house with 2 other girls. The house is staffed 24 hours a day, 7 days a week. Grace has had a hard time in care. She was removed when she was 1 year old, and she has lived in over 10 different placements. Sadly, in some of these placements, she suffered abuse by the carers. She is very traumatized by these experiences. Grace has a lot of questions about her time in care and wonders what she can do to find some answers. She likes where she is currently living, but this placement will come to an end when she turns 18, and she hasn't been told where she will be living after this. She also wonders what she will do for money, as she is not currently working. Grace has a 1-year-old daughter named Ruby. Ruby lives with Grace's aunt. Grace is happy for Ruby to continue living with her aunt, as she doesn't feel like she can care for her daughter full time. The only problem with this arrangement is that her aunt is not letting her see Ruby. Even though Grace can't care for her daughter right now, she still wants to see her and spend time with her. Grace recently went to court for a criminal matter. She was charged with shoplifting. Police alleged that she stole a small amount of makeup from Mecca. She pled guilty to the matter and received a caution. When she was arrested for this offence, she was taken back to the police station and kept in custody overnight before she attended court. She had to give the police her handbag and her phone was in it. Even though her matter at court has finished, the police have still not returned her handbag and phone, and she's wondering how she can get this back. All right, so from the scenario, I know it was quite dense, but are there any legal issues that people can identify, or even any topic areas that think, Grace might need to see a lawyer for that particular issue? Police have not returned her personal items. Absolutely. That is definitely a legal issue. Access to her daughter. Absolutely another legal issue. Seeing her daughter. Absolutely. Is there anything else that anyone can think of? There were some things in there about out-of-home care, not knowing where she's going to live. All right. Accommodation after care. Absolutely. Abuse suffered previously. Very sad, but absolutely it's a legal issue. All right, that's fantastic. Thank you, everyone. I think I'll move through, but transition plan, someone said. Again, absolutely, and that's one of the topics I'll be talking about. Everything that everyone's identified are legal issues for Grace. So the legal issues I've identified: leaving care plans, which I'll talk about, a legal file audit, victim services, so potential claims for the abuse that she suffered, income, she had questions about income, accessing information about her time in care, contact issues with Ruby, and getting property back from the police. Thanks, Bridget. All right. So I've just broken the scenario down into 3 parts. The first part deals with some out-of-home care issues and some legal issues that Grace is having. So we know that she's had a hard time in care. As we've said, she has questions about her time in care, and there's a lot of questions about her future. Where's she going to live? What is she going to do for money? Bridget, if you just want to flick to the next slide for me. Thank you so much. So there's a document called a leaving care plan. So a leaving care plan is a document that sets out how the minister will provide assistance to the young person until they are 25 years of age. So it's a document that is prepared in consultation with a young person, and it is future focused. It is supposed to make plans and make provisions until the young person is about 25, and it's about how can they achieve particular goals that they've identified, or any gaps in their in the next couple of years they've identified. What can DCJ do to step in and help out the young person? So the categories that are typically contained within this leaving care plan are on the screen: culture and connection, health, education, training and employment, living skills, legal matters, financial support and entitlements, and accommodation. So the ones that I've highlighted there are especially relevant to Grace, as we discussed in the scenario. So if I was talking to Grace and she was raising these questions, the first thing I would be doing is talking to her about a leaving care plan. Do you know about this? Has your caseworker talked to you about a leaving care plan? Because if they had, and if that was in the works, if it was being prepared, she wouldn't have these questions. So DCJ has a duty of care to people that are under its care, and that extends until they're 25. So Grace has questions about where she's going to live. We know that she is currently living in a very supported style of accommodation. It's staffed 24 hours a day by carers. So I would be talking to Grace about potential transition placements where she might live in an apartment, and DCJ could support her with drop-in staff. Could be daily, could be weekly, and that might be slowly transitioned out. So I would be talking to her about that, and I would be encouraging her to speak to her caseworker about those options, and that should be something that is mapped out for her. Finance, we know that Grace is not currently working at the moment. Sorry, Bridget, you're right, just to go back to the, sorry, thank you. We know that Grace is not working at the moment and she doesn't have any income. So what's that going to look like for Grace? We would talk to her about what she wants to do in terms of employment or training. Are there courses she wants to do? Does she want to do something at TAFE or uni? Or does she want to get straight into work? Alternatively, she might not be ready for work or any type of training. And so we need to be talking to her about Centrelink benefits. Certainly she'd be eligible to some now, but we also want to make those provisions for when she turns 18. That should all be mapped out in her leaving care plan. Thank you, Bridget. So a leaving care plan contains two parts. The first part is the aftercare case plan, and this is where it outlines the issues and goals the young person has, and strategies about how DCJ will address these. So again, it's having a conversation with Grace. What do you want for the future? What courses do you want to do? Where do you want to live? What relationships do you want to maintain? Do you want to get your license? Do you need a car? Do you need to travel to see family? It's all these types of things. Do you need counselling? Do you need health support? It's identifying that and then putting a plan in place as to how DCJ will support the young person. And the second part of the leaving care plan is a financial plan, and that are the fund that plan is the funds that DCJ will put aside to make those goals a reality. If she wants to do a particular course, how much is that going to cost? Let's put the money aside. She needs flights to fly back to country and spend time with family. How much is that going to cost? Let's put the money aside. These conversations should naturally be had between a young person and a caseworker, but in this circumstance, Grace hasn't been told about a leaving care plan. She doesn't know. So it might be at that time a good time for someone like me, a civil children's lawyer, to get involved, start some advocacy around a leaving care plan with her caseworker to say, hey, what's going on? Is this being prepared? And then advocate for her around what should be contained within that plan. So eligibility for a leaving care plan, the main eligibility is that someone has been in the care of the minister for a minimum of a year and that they're aging out of care. So that they're in Grace's circumstances, she's 17, turning 18, she's aging out of that care, she's becoming an adult, and so a leaving care plan is available to her. It's not available to someone where a guardianship or an adoption order, for example, has been made. So if someone was in care for 5 years between the ages of 2 and 7, but then at the ages of 7, their grandparent adopted them, they wouldn't be entitled to a leaving care plan. And I've just popped there the relevant section under the Care and Protection Act. That's as a reminder that this is not a nicety that DCJ does. It's not something that they think is a good idea. It's something they need to do. It is legislated that they make provision for young people and they have a duty of care to them. Thanks, Bridget. Access to care records. So we also heard in our scenario that Grace has questions about her time in care. So I thought I'd just briefly touch on some avenues she can go down to get information. So while she's in care and while any young person is in care, they have a right to ask for any information that is being held about them. They have a right to read their file to add information. They might not get a copy, but under the Charter of Rights for Children in Out-of-Home Care, they have a right to access the information. Once they turn 18, they then have a right to get a copy of their file. And that takes form by the young person applying to this particular unit, which I've put here, the Care Leavers Records Access Unit, long name. But basically they fill out an application, they pop it in, we assist young people to do that, and they can get a copy of their file. Really long wait times, minimum a year, I would say, so it does take a long time. And also provision should be made to support the young person in accessing that information because it's heavy stuff. You know, this is a record about their whole life. It has information about their assumption into care or their removal into care, information about their family. In Grace's circumstances, it will have heavy information about the placements that she's been in, and there's a lot of traumatic experiences there. So a young person should be supported when they do get that, that file to go through it with them. I've also, again, just popped down the bottom there, the relevant provisions under the Care Act. Again, this is legislated that they have an entitlement to the information. They also have an entitlement to get original documents at no cost, birth certificate, photographs, medical reports and such. Legal file audit. We heard that Grace has had some very hard experiences in care, that she suffered abuse. So if I was speaking to Grace, something that would be, you know, ringing in my head is a legal file audit. So a legal file audit is a review of a young person's care files to identify any potential legal claims or entitlements. Thanks, Bridget. You can load the next couple of bits. Thank you. So basically when a young person is aging out of care, this is the typical way that it happens, is that somebody will turn 18, and if they've been in care for, I think it's over 2 years, we'll see on the next slide in a minute, their file, their DCJ caseworker will send their file to a private lawyer who then reviews their entire file. They will then produce a report that identifies any potential claims that should be made. These might be claims for victim services, if there has been any violent acts that have occurred against the young person while they are in care. It could also be claims against the state if there are any claims for negligence because of the placements they were in. But basically, this is a process that occurs. DCJ has a policy around it, and it's a process that should benefit a young person. Our clients don't always know about this process. So that means that it could either have been missed or maybe they haven't been told about it. But if I was speaking to a 17-year-old young person and they're saying that all this stuff has happened to me in care, I'd be saying, well, a legal file audit is going to happen when you turn 18. A report is going to be produced and we should go through that with you, and we should make sure that that report covers all of those claims and all of those things that you're identifying. I popped a note down the bottom that a young person does not need to go through a legal file audit in order to be eligible to make claims. So this is a process that should happen, but it's not strictly necessary for a young person to make claims. They can do that without a legal file audit. If it has been missed or something's gone wrong, they are entitled to just make those claims on their own. They can see a lawyer about that. But this is a process that is available to them, and in Grace's circumstances, might help her to get some recognition payments and some compensation for the sad abuse that she suffered in care. Thanks, Bridget. So eligibility. A child or young person has been in the parental responsibility to the minister for 2 years or more and aged 15 years or older. So sometimes legal file audits can happen at an earlier point, and then a supplementary report can be made when they're 18. So it might be done when they're 15 or 16, a report's produced, and then, we might request, or the young person might request another one to take place when they turn 18 to say, okay, well, there's an extra 2 years. Can you please do a supplementary report? That can happen as well. But that's when a legal file audit can occur. But yeah, it is also very typical that once a person turns 18, that's when that process kicks in. All right, second part of the scenario, we know that Ruby has a little daughter, sorry, Grace has a little daughter called Ruby, and that Ruby lives with Grace's aunt. Grace is happy for this to continue. She doesn't feel like she can care for her daughter at the moment. However, her aunt isn't letting her see Ruby, and Grace wants to see her, understandably so. So what can Grace do about this? Thanks, Bridget. So I thought this would be a good issue to put in to distinguish between family and DCJ. So we know in Grace's circumstances that DCJ is involved and that she is PR to the minister. However, in this scenario, we haven't heard about that in Ruby's circumstances, the daughter. We haven't heard that Ruby is in the care of the minister. So if there is a dispute within a family and there are no orders for parental responsibility, if there's no DCJ involvement, that means it's a family law matter. So in Ruby's situation, Grace would need to see a family lawyer because DCJ is not involved. So if I was talking to Grace and heard about her circumstances and that she wanted to see her daughter, I would be advising her to see a family lawyer. Conversations with Grace would include things about options for contact and potential orders that can be made in family court. We know that Grace is not in a position to care for her daughter full time. So it might be that some kind of final order for responsibility is made in favour of the aunt, but there should still be contact orders, time spent with orders made for Grace to see her daughter. And there's also legally assisted mediations where lawyers can step in, and that's part of the family law process, that a mediation will take place before going to court in most circumstances. So we would talk to Grace around that and talk her through the different options for contact. All right, and the third part of the scenario, we know that Grace recently went to court. The matter is finalised. She's pled guilty, received a sentence, a caution. When she was arrested and held at the police station, she had to give them her bag, which had it in her phone. She hasn't got it back. She wants to know how to get it back. So the reason that I included this this part of the scenario is because speaking for myself, and I'm sure Jane can say the same thing, nearly every young person I come into contact with in my work needs some property back from the police. This is very, very common. And so I thought it might be useful to have some information about how to get property back, because it is quite easy. But basically, everyone has a right to get their property returned. And there are two conditions that need to be met before you can get your property back. Number one, the police no longer require it for evidence. Number two, it lawfully belongs to you. In Grace's circumstances, her bag and her phone, they're hers. That's what we're told. They were hers. So that's fine. It lawfully belongs to her. We're also told that her matter has concluded. She's pled guilty. She's been sentenced. That means the police should no longer require it for evidence. If Grace had pled not guilty and she decided to fight her matter in court and it was set for a hearing, she could try and get her property back, but it's very unlikely that the police are going to give it back to her. They'll probably say, no, the matter's still ongoing. We need it for evidence. Whether they actually need it for evidence is one thing, but they're going to say that the matter's still ongoing, can't have it back. So typically it's when a matter's concluded, the police don't need it, it belongs to you. All you need to do is contact the officer in charge and say, hey, you've got my property. Can I have it back? And I popped in there the relevant section of the relevant piece of legislation, the LEPRA, Law Enforcement Police and Powers and Responsibilities Act. Compensation can be sought for property that police destroy if they haven't told you they're going to destroy it. So we have a few matters in our practice where a matter's concluded, we've tried to get the property back and the police has said, oh no, we've destroyed it, it's gone. And we say, okay, can you give us the record to show us that you let our client know that you were going to destroy it and they had X amount of days to come and get it. When they don't have the record, we then seek compensation, which usually takes form by sending a letter of demand, setting out the circumstances. You had the property, you didn't advise us that we could come and get it. It's worth X amount of dollars. Please give us some compensation. That process can take a very long time. It has to go through the police channels, and it can take a very long time to get compensation, but it is something that we do in our practice, and it is something that anyone, and Grace would have a right to do if for some reason the police destroyed her property after the conclusion of her matter. So that was Grace and Ash, our two scenarios. So we've just got some resources here. I've just put together some information about the service that I work for. So I'm part of the Children's Civil Legal Service in Legal Aid. So we're a specialist service designed to work with young people in relation to civil matters. I've put the eligibility there on the screen. Sadly, we can't help everyone, but of course we love to help where we can. The criteria is that young people are aged between 10 and 19, that they are or have been in the criminal justice system, so past or present, are either in youth Koori court, which is an Aboriginal sentencing court in the children's court. So they're either in that court, they're in out of home care or have been, or they're homeless or at risk of homelessness. They need to be linked to Dubbo or Sydney, and you'll see some exclusions there. So it's quite a limited area that we can assist. Obviously, as well, they need to consent to the referral, and they have a civil law issue. I've put the legal aid phone number there. So at any time, you're welcome to ring up and talk about a young person's circumstances if they consent. And if legal aid find that it meets the eligibility, they'll shoot it on through to us and we can help out. So that's our team, and I'll pass it on to Jane. There's some resources she has as well.
Okay, thanks, Lorissa. These resources are mostly about legal information, not so much about available legal services, but you will find that the legal information probably helps you find your way to services. I apologise if the links, this came from a slide last year, so I apologise if the links don't work. Hopefully they do. But I just want to talk, I haven't unfortunately added a slide about the Shopfront and our eligibility criteria, but I'll just really briefly address it and also talk about other community legal centres. So the Shopfront is a legal service for young people aged 25 and under, who are primarily, our target group is young people who are experiencing homelessness or at risk of homelessness or history of homelessness. But we don't exclusively work with young people in that category. We may have clients who have never been homeless but have complex needs, or who have some kind of legal problem which really can't be addressed elsewhere. So if you are a youth worker or you work in a youth service and you're not really sure and you've got a client who's aged 25 or under, please contact us and we'll certainly try to talk you through whether we can assist this young person or whether we can refer them to another service. There are other community legal centres that work with young people under 18. Youth Law Australia is an Australia-wide service. They don't generally do one-to-one casework with young people, but they do have quite a few resources on their website. They also have an online advice service where they can answer sort of fairly straightforward legal questions via email or online. So that could be an option for some young people where their legal issues maybe are not too complex, or they're just looking for a bit of guidance in the right direction. There's also in New South Wales, there are other CLCs, some of whom do have specialist children and youth lawyers. Marrickville Legal Centre is a really good example. They have a youth legal service working with young people, I think aged 24 and under, or under 25. They are funded statewide for that, so you don't have to be in that normal Marrickville catchment area. There are other community legal centres in regional areas, such as Hunter and others that do have, I think Macarthur, they do have at least a part-time youth lawyer position at some of those centres. For criminal matters, Legal Aid has its children's legal service, so that's different from the children's civil law service that Lorissa works for. It is the children's legal service that provides lawyers at criminal children's courts all around the place. They also run the Legal Aid Youth Hotline, which some of you might know about. The number of that hotline is 1800 10 18 10. So anyone under 18 wanting advice about having to go to court for a criminal matter or a Young Offenders Act intervention, a fine, or contact with police, that's the service for them. We're really getting a bit short on time, but so I don't want to go into too much more detail about legal services, but please, if you would like to, if you're not really quite sure about where to go for a young person's legal problem, what kind of legal problem it is, or even if it's a legal problem at all, we'd certainly welcome contact from you. We at the Shopfront really love warm referrals, meaning we really love youth services contacting us on behalf of a client. Of course, clients can self-refer, but if they are involved with a youth service, if they've got a worker supporting them, we always find it really helpful to hear from the worker. We don't really want to hear from parents, if possible. But please get in contact, and if you go to our website, you just Google the Shopfront Youth Legal Centre, you'll find our contact details, phone number and email address there. We're always happy to try to point you in the right direction. Do we have a few minutes for questions? I think we may have 5 to 10 minutes.
Yeah,
left.
we have, Jane. There's some that came in during your scenario. A question: if somebody drives a car that isn't registered in their name and has an accident, about what the process might be.
Yeah, it doesn't really matter whose name the car is registered under, as long as it's registered. I mean, if a car's unregistered and you're driving it, then that is a problem. Not only is it an offence to use an unregistered car, which will get you a pretty hefty fine, it also means if a car is unregistered, it also means you don't have third-party insurance. Now, third-party insurance is the policy, it's your green slip that you have to take out when you register your car. It means that if you have a crash and somebody is injured, it means they're covered. So if you have an accident which causes someone to be personally injured and the car is unregistered, it means you don't have third-party insurance. So I guess technically somebody who gets injured in that accident could be coming after you personally for all of their medical costs and compensation for pain and suffering. But if the car is registered, but it just happens to be not registered in your name, that really doesn't really make any difference, okay? But obviously, if you're the owner of the car, like Ash, you now own the car, you haven't transferred the rego into your name, it means you can't take out comprehensive insurance or third-party property insurance in your name, so it probably means the car's not going to be insured for damage to property. So yeah, the important thing really is that the car is registered. One thing is we were talking about transferring rego. So if you don't transfer registration, if you buy a car and you don't transfer the rego into your name within 14 days, it's not actually an offence. You can't get a fine or a criminal penalty for it. But when you do eventually transfer the rego, you'll incur late transfer fees, so it'll cost you more money, okay? One really important thing though, if you are a driver, if you have a licence or if you have a vehicle registered, I think, if you change your residential address, you must update it with Transport for New South Wales. And if you don't do that within, I think it's 14 days, that actually is an offence. And the reason why they need you to keep updating your address is because if you do incur like a camera detected penalty or there's a crash or something and they need to track you down to send you a fine or for whatever reason, it's so that they can actually reach you at your address. So just be mindful of that also with young people. If they have licenses and they're moving around a lot, they really do need to update their address. Okay, there's some other questions as well. One's about, maybe over to you, Lorissa. Can a legal file audit be requested? In our experience, these audits are not automatically happening when a young person ages out of care.
So yes, they can be requested. However, the request has to come from the caseworker. So if we were talking to a young person and they hadn't heard about a legal file audit before, had some questions about it, we'd be directing them to their caseworker, because the request for a legal file audit needs to come from that caseworker. For example, one of my clients at the moment, we're trying to push through her legal file audit, and that involves me liaising with the caseworker, chasing her up. Hey, have you sent over this client's files yet to legal? Because we need to get this process started. So it can be requested, remembering that there are eligibility requirements for the file audit. But if the client meets that, yes, it can be, needs to come from the caseworker.
Thanks,
I can also
Lorissa.
see, sorry, Bridget.
Question about the extent of your service, whether it extends as far as Wollongong.
No, sadly. It is a question that, yes, I feel pretty confident. It is a question that I would like to just check with my team, but I do feel pretty confident that the answer is no. But I might even just shoot them a message now with the next couple of minutes, and I know I'll get an answer back. But sadly, the answer is no. I'm fairly certain. Sorry.
There's just a comment from Shani
yes.
that the strip search also required parent or guardian support.
Generally, yes, but they can dispense with that, you know, if it's not reasonably practicable, or, you know, if the young person doesn't want to be waiting around for somebody to come, for a support person to come, then they're not obliged to wait. So, yeah, it is a right, but it's one that's not really often observed, I have to say.
Yeah, and another comment from Rhiannon, just saying that young people are priority clients for the Civil Law Division. So even if you don't qualify for the Children's Civil Law Service, contact Legal Aid anyway, and they should be referred on for advice.
Yes, sorry, I should have added that, but thank you, Rhiannon, that's exactly right.
Yeah, and that might be at their closest legal office rather than with the specialist Children's Civil Law Service.
And could I just add that if you are having difficulty negotiating your way around legal aid, because they are, and I don't mean any disrespect, and I know that it won't be taken that way, they are a very large organisation, and if you are sort of calling the 1300 number, it may take a while to end up with the right section. So if you are sort of having issues negotiating your way through legal aid, again, you could contact us at the Shopfront, and we can try to maybe make a referral into the right section. That's particularly, I think, with criminal matters, actually, and particularly if it's a young adult in an adult court. Sometimes people can get lost in the system, unfortunately. So we can maybe try to help. Also, the Shopfront, we don't really have any geographical boundaries to our service. In practice, we do, like we can't appear at court at Dubbo, for example, but we can give telephone advice to people and try to make referrals to people wherever they are in New South Wales. And also, just on that point about the file audit and the victims compensation, at the Shopfront, we do victims compensation as well. So if you're finding that a file audit was not done, or, you know, and victims compensation application was not adequately pursued by DCJ when a young person was in care, also you could contact us, and we could possibly either advocate for that to happen, or actually make the victims help lodge the victims compensation application on behalf of the young person.
Thank you, Jane, and thank you, Lorissa. I note that we're just out of time now. If anyone has any follow-up questions, please feel free to email the CLE branch, and we can organise to have your questions answered. Just to quickly let people know, we have a webinar coming up during Law Week in May, where we're having a panel of people from different ombudsman services who are going to talk about what their service does and when you should access them. So great thank you to Jane and Lorissa for making this webinar an interactive presentation with lots of interesting information for people, and to let you know that I will share links in the email you receive after the webinar to the Shopfront and to the Children's Civil Law Service. And there was a question about the nomination form. It is on the Revenue New South Wales website, and I'll put a link to that if you're going to nominate someone else as being the driver. I'll include a link to that in the email, and I'll also include a PDF copy of the handout. There is some useful information there that might be helpful for people after today's webinar. So we'll end the webinar now, and thank you everybody for joining us. And thanks again, Jane and Lorissa. Goodbye, everybody.
Thanks so much.
Thanks,
Bye.
everyone.
Thanks, everyone. Bye.